state exists to preserve freedom. Separation of powers is central to our Constitution. It is emphatically the province and duty of the judiciary to say what the law is, not what it should be. I am very honored to present Mr. Levy to the law school community today. Mr. Robert A. Levy is chairman of the Cato Institute's board of directors. He joined the Cato as senior fellow in constitutional studies in 1997 after 25 years in business. He also sits on boards of Institute for Justice, the Federalist Society, and George Mason University School of Law. He founded CDA Investment Technologies, a major provider of financial information software, and was its CEO until 1991. Mr. Levy clerked for Judge Royce Lambers of the United States District Court in Washington, D.C., and for Judge Douglas H. Ginsburg on the U.S. Court of Appeals for the District of Columbia Circuit. From 1997 until 2004, Mr. Levy was an adjunct professor of law at Georgetown University. He has written numerous articles on investments, law, and public policy, and his writing has appeared in New York Times, Wall Street Journal, USA Today, Washington Post, National Review, and many other publications. Mr. Levy has also discussed public policy on national radio and TV programs, including ABC's Nightline, CNN's Crossfire, Fox's O'Reilly Factor, MSNBC's Hardball, and NBC's Today Show. His latest book, co-authored with William Meller, is The 30 Dozen: How 12 Supreme Court Cases Radically Expanded Government and Eroded Freedom. Mr. Levy received his PhD in business from the American University and his JD degree from George Mason University School of Law. Please join me in welcoming Mr. Levy.
Can you hear this in the back? Okay. It's great to be with you. I didn't go to law school until I was in my 50s, so I may be the only federal law clerk that you're likely to meet that was older than both of the judges that he clerked for. So I was older than Judge Lamberth by maybe 3 years, and maybe 4 years, Judge Ginsburg. And of course, the marshals guard the U.S. courthouse in Washington, D.C. with great diligence, and they couldn't get it through their head that anybody as old as I was a law clerk. And so for 2 years, it was every morning it would be "Good morning, Your Honor," "Good morning, Judge Levy." And I never disabused them of that notion. I was treated with great deference in the halls of the courthouse. And of course, once I got up into the chambers, they told me to go fill the water jugs in the jury box like the other clerks. Clerking is a great experience, which I highly recommend if you get a chance to do that, both trial and appellate clerking. Today I'm going to talk about how the Supreme Court has amended the Constitution, but before I talk about a few of the worst cases, which are based on the book that I co-authored with Chip Miller. Chip is the president of the Institute for Justice. I want to set the stage with a little bit of background, and that is some comments on how liberals and conservatives look at the Constitution differently and how their views differ in turn from the views of libertarians such as me and my colleagues at the Cato Institute. Now, when I talk about libertarians, I'm not talking about the Libertarian Political Party. I'm talking about libertarianism as a political philosophy focusing on free market, private property, limited government, and strictly support for individual rights. So at Cato, for example, we don't endorse candidates, we don't endorse political parties, but, and as a matter of fact, as you're going to hear, we're equally critical of Democrats and Republicans, liberals and conservatives. What we do have is a consistent, I'd call it minimalist view about the proper role of government. Conservatives will agree with us on some issues. They tend to be domestic, economic, regulatory, tax, budget, fiscal issues. Liberals will agree with us on the social issues, same-sex marriage, drug legalization. Liberals tend to agree with us on a more liberalized immigration reform that focuses on work permits rather than deporting 12 million illegal aliens. And liberals will agree with us on a non-interventionist foreign policy. So how is it that libertarians, are libertarians inconsistent because they agree with liberals sometimes and conservatives? No, we're not. It's liberals and conservatives that are inconsistent. And to illustrate that, I want to suggest to you that you can capture the essence of the Constitution, and for that matter, the essence of the whole federal system, by looking at the final two provisions in the Bill of Rights. the 9th and 10th Amendment. For those of you who haven't had con law, the 10th Amendment focuses on powers of government, and basically it says that the federal government has the powers that are enumerated in the Constitution, and if they're not enumerated and not delegated to the federal government, then they're reserved to the states, or depending on provisions of state law, they're reserved directly to the people. Now, the kinds of powers we're talking about, if you look at Article 1, Section 8, you'll find 18 powers listed there, and there are things like the power to establish post offices and coin money and regulate interstate commerce, and on and on. There's quite a list of them. Conservatives and libertarians tend to agree on this narrow and constrained view of federal power, but there are a couple of key exceptions. The first is that conservatives, but not libertarians, are willing to federalize, and by that I mean assign responsibility to the federal government, a significant amount of both criminal and civil law. If you want an example in the criminal law area, take a look at our totally feckless war on drugs, for which there's no constitutional authority. There's some crimes that are listed in the Constitution, like espionage, piracy, counterfeiting. But for the most part, criminal law prosecution is a matter for state and local governments. And yet conservatives believe that because the war on drugs is a very important thing to prosecute, that they can overlook the fact that there's no constitutional authority for that. If you want an example in the civil law area, take a look at the debate that's unfolding now regarding Obamacare, where the conservatives are insistent that the health care reform include malpractice reform. Now, it may be that malpractice reform is a heck of a good idea. I tend to think that it is. But again, there's no constitutional authority for the federal government to be involved in that. When you ask what's the constitutional pedigree, the answer from conservatives is it's the Commerce Clause. Of course, that's the answer to just about everything. Well, if you know anything about malpractice, you know typically it's an in-state patient suing a doctor who lives in the same state for an injury that all occurred within one state. It's hard to imagine that morphing into a regulation of interstate commerce. And yet again, because conservatives believe malpractice reform is something that's important, then they are willing to overlook the fact that there's no constitutional authority for it. Of course, the intent was that the federal government be limited to this narrow list of powers. The libertarian position is that no matter how important some goal is, some objective, like malpractice reform, if there's no constitutional authority, then the federal government has to step aside and leave the matter up to the states. That was the intent of the framers. That was not what has transpired. Today, the federal government is immersed in matters ranging from our public school system, for which there's no constitutional authority, to hurricane relief, welfare, or retirement system, medical care, family planning, housing, aid to the arts, and on and on and on ad nauseum. Now, there's a second area that conservatives and libertarians differ when it comes to powers of government, and that is that conservatives are much more willing than libertarians to focus an awful lot of power in one particular branch of government, and I mean the executive branch, and I mean especially in this post-9/11 environment where there's this trade-off between national security and civil liberties. The libertarians remind their conservative friends that too much concentrated power in a single branch of government threatens the notion of separation of powers that's been a cornerstone of the Constitution for more than 2 centuries. So the executive branch, the administration, sorry to say, I mean most particularly the George W. Bush administration, may not unilaterally establish what the rules are, because that's not an executive function, it's a legislative function. And while the executive branch may prosecute infractions, it may not determine guilt or innocence, and it may not, after the fact, determine whether its own actions have comported with the dictates of the Constitution, because that too is not an executive function, that's a judicial function. So that's the powers of government perspective, grounded on the 10th Amendment, separation of powers doctrine. Now, I also mentioned the 9th Amendment, which doesn't deal with powers at all, it deals with rights. And what it says is that the enumeration of certain rights in the Constitution shouldn't be read as if they're the only rights we have. We have lots of other rights, rights that predated the Constitution and that we retain. And the 9th Amendment uses the word retain. You can't retain what you didn't already have. So we retain these rights. They existed before the Constitution was written, and indeed before governments were even formed. And that safeguard, this notion of retained rights, imposes another powerful discipline on federal behavior. Because what it says is that even if the federal government follows the dictates of the 10th Amendment and only exercises the powers that are enumerated, even if the federal government abides by that rule, the 9th Amendment instructs that in exercising even those limited powers, those powers can't be exercised in a manner that violates our rights. And if you want to know which rights can't be violated, says the 9th Amendment, it's not just the enumerated rights, speech, press, religion, protection against unreasonable searches, etc. It's all of those for sure, but it's also a long list, an innumerable list of unenumerated rights. And that would include, in the libertarian view, the right to gamble, for example, or for that matter, the right to smoke marijuana. Now notice that the presumptions in the 9th and 10th Amendment are exactly opposite one another, and if you capture that, you capture the entire structure of the Constitution. The 10th Amendment says that the power isn't there, the government doesn't have it. The 9th Amendment is just the reverse. It says merely because the right isn't there doesn't mean that we don't have it. We have a long list of rights, again, predating the Constitution, that are not listed in the Constitution. So if you want to identify a single provision of the Constitution that separates conservatives and libertarians, it would probably be the 9th Amendment. Conservatives treat the 9th Amendment, and here I'm using former Judge Robert Bork's memorable term. He said the 9th Amendment is an ink blot. It should be ignored. Nobody knows what it means. It's as if somebody spilled ink on the portion of the 9th Amendment that would have identified all of these unenumerated rights that the libertarians insist that we have. Of course, the libertarians treat the 9th Amendment as if it means something. It's not an ink blot, and specifically, libertarians argue that it refers to our natural rights, the rights that we had by virtue of our nature as rational human beings that we had pre-government and that we still retain. Now, what kinds of rights are these? These are all of the so-called negative rights. It sounds like a pejorative term, but it's not meant to be. A negative right is simply a right that doesn't impose affirmative obligations on anyone else. And that should be contrasted with a positive right, or what ought properly be called an entitlement, which does impose affirmative obligations on other people. And to flesh that out a bit, consider the right to the pursuit of happiness. That's a negative right. I can pursue happiness. I don't need your help. Just stay out of my way. Don't exercise force or fraud against me. So that's a negative right in the sense that it doesn't impose affirmative obligations on you. The only obligation that you have is the negative obligation to leave me alone. Suppose, however, I had a right to happiness. Now, I'm not talking now about the pursuit of happiness, but actually the realization of happiness, the attainment of a happy state. That would be a positive right because it does impose affirmative obligations on each and every one of you. Because if I have an enforceable right, and when I say, by the way, I have a right, it presupposes that I have a remedy. That is, if the right's violated, I can do something about it, because a right without a remedy is as if I didn't have the right at all. So if I have an enforceable right to happiness, that means at a minimum that you wouldn't be able to do anything that makes me unhappy. And if you did, I'd be able to get redress, typically by going to court and insisting that you stop doing that, and getting an injunction against you doing that. And of course, that would interfere with your own right to the pursuit of happiness. So you can see that positive rights are rights that impose affirmative obligations on other people. Now, the positive rights that we hear most about are not these abstract rights like the right to happiness, but they're things that are pretty closely related. They are the right to a minimum wage, the right to education, housing, welfare, and on, the long list of rights that you've heard so much about. If I have a positive right, if I have a right to housing, an enforceable right, it means that somewhere somebody has the affirmative obligation to provide me with a house. Or if not with a house, then typically through the tax system with the money by which I can obtain a house. These positive rights are integral to the liberal view of the proper role of government. And since I've been critical of the conservatives, I want to be an equal opportunity critic. Liberals focus on positive rights. And that's why liberals embrace big government. Positive rights, by definition, as I mentioned, impose obligations on other people. Well, occasionally, the people who are being imposed upon don't like that idea. When folks tell me that I'm responsible for providing housing for somebody else because they have a right to housing, sometimes I resist that obligation. And so what can be done when there's resistance? Well, you bring in the only entity in our system of government that's authorized to use force, and that is the government. And you compel the obligation to be met. And again, typically that's done through the tax code. So you have liberals embracing big government because they embrace positive rights. But paradoxically, there is, especially again in this post-9/11 environment, some concern about liberals about big government when it comes to two agencies of government. All the other agencies can get as big as they want, but two agencies concern liberals, and that is the Defense Department and the Justice Department. And those two agencies are charged, as you know, with an indisputably legitimate function of government, which is to protect us against domestic and foreign predators. So imagine if Congress were to delegate to the Justice Department, particularly if it was under the in charge of Gonzales or Ashcroft, if Congress were to delegate to the Justice Department the power to craft regulations regarding the trade-off between national security and civil liberties, and it gave the Justice Department no more guidance than keep us safe from the terrorists. Now, folks on the left would be apoplectic, and they would have every right to be, because it is not the job of the Justice Department to be crafting regulations. That's the job of the U.S. Congress. But when the same Congress delegates to the Environmental Protection Agency the power to craft rules regarding the trade-off between a clean environment and economic growth, and it says to the EPA, keep us safe from pollutants, the folks on the left applaud enthusiastically. So could it be that pollutants are a greater threat than terrorists? I don't think so. What is more likely the case is that the left has a selective indignation about big government, and that reflects an inconsistency in the liberal mindset, just as there is on occasion an inconsistency in the conservative mindset about the proper role of government, and that, I think, is the foundational question. What is the proper role of government? And I think in examining that question, you can look at the Constitution through these two prisms. The powers of government prism, which is the 10th Amendment, the rights of individuals prism is the 9th Amendment, and if you want to capture the libertarian view in a nutshell, it is that the powers of government should be interpreted very narrowly and the rights of individuals should be interpreted very broadly, and we would argue that that was precisely the vision of the framers. So that's a little bit of background, and against that background, let me talk about a few of these cases that I think have done a great deal of damage with this preface, and that is that it's been now 220 years since the Constitution and the Bill of Rights were ratified, and it's been amended only 17 times, since, other than the first 10. 17 times. So why have there been so few changes, even though the framers could never have imagined what our 21st century world would look like? And I think there are lots of reasons, but three of which are particularly relevant here. Two of them are good reasons, one's not so good. The two good reasons are, first, that the framers were geniuses, and they crafted a document, and their vision of liberty was every bit as relevant today as it was back then. Secondly, in the exercise of their genius, they had the foresight to make it very difficult to amend the Constitution. As you know, essentially 2/3 of both houses have to propose amendments. They have to be ratified by 3/4 of the states. That isn't easy, and as a result, it's only happened 17 times, and we have a very stable government. The one bad reason is, in my view, the Supreme Court, through the back door, has accomplished what the legislatures and the people could not have accomplished through the prescribed amendment process. In effect, the Supreme Court has, because of these destructive decisions that I'm going to mention, has rewritten the Constitution. The court has sort of lost its compass, and that has profound implications for all of us. And so that's what I'd like to address now. Several cases, I'm not going to be able to cover all dozen of them that are in the book that I co-authored, but some of the cases. In no particular order. I'm not talking about the worst case and the next worst, etc., but all of them are bad enough. And the interesting thing is that even those are, mostly these are old cases. I'm not covering anything that isn't any good law, isn't still good law, so I'm not going back to Dred Scott or or Plessy. I'm talking about cases that still have an on a recurring destructive effect. So, but basically, I'm talking about the New Deal today. So even though some of these cases are 70, 80 years old, they have enormous relevance to debates that are unfolding every day that we pick up the newspaper. And these first several cases are a perfect example of that. This first case is a case called Helvering v. Davis. See, I come up here and the weather's so cold, and I come from Naples, Florida. I get the sniffles as soon as I come to Chicago. Helvering v. Davis is a 1937 case that most of you have never even heard of. You may not have even studied it in con law. And it's about the issue in Helvering v. Davis. It's about the General Welfare Clause, but the issue in Helvering v. Davis is whether or not the Social Security system is constitutional. Now, of course, you have to think like a judge. And so the issue is not whether Social Security is a good idea. It's not whether the system is actuarially sound. It's not whether, if you were in my shoes, you'd like getting your check every month. It's not about that at all. It's about whether there's any constitutional authority for the federal government to be involved in our retirement system. And if you ask the proponents of Social Security, they will point to the General Welfare Clause. That is the power to tax, in this case, Social Security or payroll taxes, in order to provide for the general welfare. And this became a battle between Madison and Hamilton. Hamilton said that the General Welfare Clause is an extra added power of Congress, over and above all the other powers that are listed in Article 1. Section 8, the General Welfare Clause gives Congress one more power, and that is the power to tax, in order to provide for anything that could be characterized as serving the general welfare. Madison said that that cannot be the case, because if that were the case, there would be no reason to enumerate all these other powers, because just about anything can be characterized as promoting the general welfare. And Madison even went a step further. He said not only isn't the General Welfare Clause an extra added power of Congress, it's actually a restriction on Congress's powers. What it means is that even if Congress exercises only the other powers that are enumerated, Congress cannot exercise those other powers in a manner that serves anything but the general welfare. That is, these powers cannot be exercised in a manner that serves special interests, which Madison called factions. Today we call them the special interests. So Madison said the General Welfare Clause is a restriction on the exercise of the other powers. Of course, the court took a look at this and basically said Hamilton wins and Madison loses. And that opened up the floodgates through which the redistributive state was ready to pour, taking money from some people and giving it to others without any effective constitutional constraints. And you're seeing that play out right now in the debate over Obamacare. There are two justifications for Obamacare that are asserted by the administration. The first is the taxing power to provide for the general welfare. The power to impose a tax in order to provide for the general welfare. That's what makes it constitutional, says the administration, to have an insurance mandate that says you must buy health insurance, and if you don't buy health insurance, you're going to have to pay what they call a tax, but what the courts have been calling a penalty. So that's one justification for Obamacare. And the second justification for Obamacare brings us to the second case, and that justification is the Commerce Clause. And the case involved, again, if you've studied con law, I'm pretty sure you've covered this case, Wickard v. Filburn, a 1942 case where the issue was a pretty simple one. Can the power to regulate interstate commerce, which quite clearly does exist in the Constitution, that power is one of those that are enumerated, can that be extended to activities that are not interstate and not commerce? And if you think the answer to that is self-evidently no, you haven't been following the Supreme Court for the last 70 years. Mr. Filburn grows wheat on his farm. He doesn't buy the wheat, he grows it, and he doesn't sell the wheat, he eats it, or he gives it to his farm animals. The Roosevelt administration during the Depression decides that the price of farm products is too low, it needs to be boosted. The way to boost prices, of course, Econ 101, is cut supply. So Roosevelt says to Filburn, you need to stop producing as much as you're producing, and Filburn says, under what authority? And Roosevelt says, we're regulating interstate commerce. And Filburn says, guess what? It's not interstate. It's my farm all within one state. I'm not selling anything across state lines. As a matter of fact, there's no commerce at all. I'm not buying, I'm growing, and I'm not selling, I'm eating. And the Supreme Court basically said, Phil Byrne, you don't get it, because if you weren't out there growing this stuff, you would have had to buy it. And if you weren't eating everything you grew, then you'd have some left over to sell. So by not buying and by not selling, you are having an impact on the supply and demand for crops. And when taken in the aggregate, along with all the other folks that are probably doing what you're doing, this could have a substantial effect on interstate commerce. So that opened up a second set of floodgates, this for the regulatory state. And now we regulate just about anything and everything under the rubric of the Commerce Clause, and it's Wickard v. Filburn, and a follow-on case, very recent case called Raich v. Gonzalez about medical marijuana, which relied on the very same principles. It's those two cases that paved the way for this, what I consider to be noxious notion that Congress can even punish the failure to purchase a product, namely health insurance, from a private company. That's unprecedented. As you may know, under current law, it's actually illegal to buy health insurance across state lines, so there's no interstate market to be regulated. And if Congress can mandate the purchase of health insurance, then why not the purchase of exercise equipment or a new fuel-efficient car or you name it? The individual mandate under Obamacare is going, if it's passed, if it's upheld by the courts, is going to extend the dominion of the federal government to virtually all manner of human conduct, and that would include non-conduct. And that's the legacy of Wickard v. Filburn. That case is going to reach the Supreme Court, we're pretty sure. There are 5 district courts that have already ruled. 3 of them have said Obamacare is okay. 2 have said it's unconstitutional. It's going up on appeal in 3 different circuits. The oral arguments are in May and June. There's likely to be a split in the circuits. Even if there isn't, if the government loses any of those cases, the Supreme Court will take the case, and I think it's the most important case the court will deal with in decades. It will test whether there are any remaining constraints on the exercise of federal power. The next case is about the Contracts Clause. The case is Home Building and Loan Association versus Blasdale in 1934. This is a clause that couldn't be more crystalline. It says, and I quote, "No state shall pass any law impairing the obligation of contracts." Well, even that wasn't clear enough for the Supreme Court, which upheld a Minnesota statute that, see if this sounds familiar, postponed mortgage payments for financially troubled homeowners, never mind the contract. And interestingly, we're seeing a replay of that today, as creditors are being pressured to waive foreclosure on subprime and other mortgages. Now, we're not just talking about contracts that were fraudulently induced, of which there were some today, for sure. But there are lots of laws on the books that prevent those contracts from being enforced. You can't enforce a contract that was induced by fraud. But we're not talking about just those. We're talking about an across-the-board waiver of foreclosure rights on the part of all creditors. And we're not talking about just foreclosures that were based on incomplete paperwork. That too is a problem today. But we're talking about mortgages that were extended to home buyers who understood the risks involved, probably also understood that they wouldn't be able to make payment, and subsequent foreclosures that were properly documented. And they are being pressured to waive those rights, and all of that would be justified by Home Building and Loan Association versus Blasdale. A fourth case, again with implications today, and that's about a provision of the Constitution that even many law students don't study, and that's the non-delegation doctrine. The non-delegation doctrine is the very first sentence in the Constitution after the preamble. It says all laws, legislation is vested, legislative power is vested in Congress. Now, the framers were smart guys, as I mentioned, and the reason they put that in there is they knew that if Congress passes an oppressive law that we don't like, as voters, we have some recourse. We can throw the bums out of office. Well, suppose, however, Congress passes laws that nobody understands, and then delegates to one of the 320 or so alphabet agencies in Washington, D.C., some of which are executive branch and some of which are independent agencies belonging to neither the executive nor the legislative branch. If Congress delegates to those agencies the power to pass rules and flesh out the laws, then the voters don't have any recourse, because these agencies are not run by elected officials. They are run by unelected bureaucrats. So the voters can't do anything about it, and the courts apparently are not going to do very much about it either. And if you like this delegation, even though the Constitution quite clearly says it can't be done, then you'll love TARP, the Troubled Asset Relief Program, which we know today as the bailout, which basically turned U.S. lawmaking power over to Henry Paulson, the Secretary of the Treasury, and then his successor, Timothy Geithner. So Paulson decides, without any congressional input whatsoever, that he's going to purchase toxic assets from some of these troubled banks. And then weeks later, again without input, he changes his mind. He says, no, we're not going to purchase toxic assets. We're going to invest directly, inject capital into these troubled financial institutions. Then Geithner comes along and decides that neither one of those ideas is that great, and what we really need, again without congressional input, is a public-private partnership, by which he means that the public, that's all of us, put up the money through the tax system, and the private, that is the bankers, reap all the benefits through the bailout. And of course along the way we expropriate, the administration expropriates $180 billion to bail out insurance giant AIG, a few tens of billions of dollars to bail out the automobile companies, despite an express declaration by Congress that there was to be no automobile bailouts. And what have the courts said? Well, they've said, we know that the first sentence of the Constitution says that all legislative power is vested in Congress, but legislation is a very complicated business nowadays, and we need the expertise in these 320 agencies. And so we're going to make an exception to the principle that says there's not to be delegation. And that exception is that delegation is okay as long as Congress crafts an intelligible principle by which these administrative agencies and executive agencies know how to flesh out the details of the law so that they're comported. The regulations are in compliance with Congress's lawmaking. Well, what's the intelligible principle that Paulson and Geithner had to follow? Nobody knows. Least of all the taxpayers that are footing the bill. The intelligible principle seemed to be make things better. And that was certainly not a coherent guide to regulatory action. The next case is a little more recent case, and that is about free speech, or particularly free speech in the context of campaign finance. The case has been partly overturned, so the case is McConnell versus Federal Election Commission, 2003 case, recently overturned in part by Citizens United, about which you've read quite a bit in the newspaper. The background is that the campaign finance reformers had this, I think, quixotic idea that money and politics should not mix. And so they passed McCain-Feingold back in 2002. Now, we know how well that worked, right? Because 2002, and then 6 years later, we had a presidential election during which more money was spent than in any election in the history of the universe. So much for campaign finance reform. McCain-Feingold ultimately was codified as BICRA, BCRA, the Bipartisan Campaign Reform Act, and it was inexplicably, in my view, upheld by the Supreme Court, in this case McConnell versus, that's McConnell as in Mitch McConnell, Senator from Kentucky, McConnell versus FEC, and the court decided in that case, McConnell v. FEC, that political speech, or at least some forms of political speech, which is, I think we would all agree, the most fundamental speech that was to be protected by the First Amendment. That is the ability of all of us to praise or criticize candidates for office. Political speech was to get less protection than pornography, than flag burning, or than Klan speech, all of which are protected by the First Amendment. But according to McCain-Feingold, if a corporation or a labor union publishes a document and engages in express advocacy, that's forbidden. So let's take a corporation like Random House, which is in the publishing business, or you can name any publishing company. If they put out a 600-page book, and somewhere within the 600 pages were 3 words, vote for Obama, or vote against Obama, that book would break the law and could be banned. And we're not supposed to be about banning books in the United States. And so the Supreme Court, I think, was motivated to take a second look at this in the case that came up later, 2010, Citizens United versus FEC. And in Citizens United, that particular provision was overruled. Namely, corporations and labor unions now can engage in express advocacy. They can use those magic words, vote for somebody or vote against somebody, in a publication. The other provision that got overturned was every bit as bad, and that was that no corporation or labor union can pay for a broadcast ad that even named the candidate. You didn't have to say vote for or vote against. You didn't have to say anything that even related to the election. You couldn't even name a candidate within 60 days of a general election or 30 days of a primary. And if you did, that would be prohibited under McCain-Feingold. And again, the Citizens United court overturned that second of these two provisions in McCain-Feingold. The issue in Citizens United was about Hillary, the movie. It was critical of Hillary Clinton. And under McCain-Feingold, it was a crazy law. It was okay to show the movie in the theaters. It was okay to sell the movie on DVD. But you could not advertise, since Citizens United, the producer, was a corporation. You could not advertise that the movie was available to be seen in the theater or available to be purchased on DVD, because that would be a broadcast ad. And you couldn't make the movie available over cable, because that would be a broadcast distribution. Both of those were overturned, were illegal under McCain-Feingold, but overturned by the court. Kennedy wrote the opinion 5-4, and I think he correctly recognized, among other things, that this money that is purportedly a problem, this is not some monolithic block of money that always comes in on a particular side of the issue. Typically, where corporations are on one side of the issue, unions are on another side. And even within the corporate community, you have companies like Walmart was a major proponent, favored Obamacare. You had Whole Foods was a major factor against Obamacare. And by the way, this case, Citizens United, I think has been misrepresented by the press in two respects, one of which is they acted as if the issue was whether corporations should be treated as persons. That's not the issue at all. That's an interesting issue about which there's a great deal of legal scholarship, but it wasn't the issue in this case. This is not about the rights of the corporations, it's about the rights of us as individuals to pool our resources and express our political views through any organization that we want. It doesn't matter whether we do it individually or we do it through the medium of a corporation or a union or a partnership or an LLC or a club or you name it. It's our rights as individuals. The second misrepresentation is that we're now going to have this flood of corporate contributions to political candidates. Not true. It is illegal for a corporation or a labor union to contribute a dime to political candidates. The only thing they can do now that they couldn't do before is they can run ads and pay for them themselves. They can't even coordinate those ads with the political candidate, but they can broadcast the ads themselves and pay for it without restriction. They would have been restricted, they would have been prohibited under McCain-Feingold. Now, is money still a problem? Well, maybe, but if money is a problem, if there's too much money, then I think the proper answer is let's have more of it, let's have more speech. And if we decide after that that the existing system doesn't work, that it leads to corruption, and by the way, there are plenty of laws on the books that deal with corruption if you find it. If you ask these politicians who are in favor of campaign finance reform to name the instances of corruption, they are very hard-pressed to come up with examples. But if there is corruption, the answer is amend the Constitution. We can't treat the First Amendment as if it's made out of tissue paper and that it's simply a loophole. Frankly, money is just a symptom of the problem. The real problem, if there is a money problem, the real problem is overweening government that sort of wormed its way into virtually every aspect of our daily lives. So we have this pervasive regulatory and redistributive state. No wonder lobbyists go running to Washington, D.C. and corporate interests and union interests, because Washington, D.C. has so much largesse to be doling out. So if you have a big money problem, it's because you have a big government problem. And if you want to get government, if you want to get money out of elections, then get government out of our wallets and out of our bedrooms, and restore the notion of enumerated, delegated, and limited powers. Let me cover one more case quickly that you're probably familiar with, and that's in part because it's recent and in part because it's a particularly interesting case, and that is Kelo versus City of New London, 2005 case. And this, of course, is about the government's power under eminent domain. So imagine that you have this cherished home that you've lived for many years, and along comes a private developer who wants to get control of your home. And he goes to the city council in New London, Connecticut, and he says, let me have Mrs. Kelo's home and the homes of all our neighbors. And the city says, for what purpose? He says, well, you know, I'm going to use that home a lot better than she knows how to use it. And what we're going to do is going to create a pharmaceutical plant, because I got some friends at Pfizer, and we're also going to build some hotels and commercial office buildings, and this will have the effect of expanding the tax base and creating lots of jobs. Well, they asked Mrs. Kelo about it. She wasn't all that excited about the prospect because she liked living where she was living. And she said, well, what about the Fifth Amendment where it says you can't take private property except for public use? And she said to the court, when I think about public use, I think about, you know, roads and military bases and government buildings. I don't think about Pfizer's pharmaceutical plants or commercial hotels or office buildings. And the Supreme Court said, well, we understand that the Fifth Amendment says public use, but we're not going to read it that way. The way we're going to read it is as if it meant public benefit, public purpose. And even though it's not a public use, we're not talking about a road, for example, it is a public benefit, public purpose, because it's creating all these jobs and it's expanding the tax base. Well, you know, if that's going to be the criteria, then nobody's home is safe from the government's bulldozers, because everybody's home can be used in a different manner, commercially or industrially, in a manner that would create some jobs and expand the tax base. And nonetheless, Mrs. Kelo did lose her home. Fortunately, there's an epilogue, and that is the Institute for Justice, on whose board I'm happy to serve, and which lost the case in court, found that, like other good public interest lawyers, there's a second court you can appeal to, and that's the Court of Public Opinion. And they mounted a media crusade, and as a result of that media crusade, 43 states now have passed laws that have, at least under state law, of course states can't affect federal law, but under state law, they've reined in the use of eminent domain for economic development purposes. And there's a good lesson there, and one is that you do have, as a public interest lawyer, access to this other source of relief, and that is the legislature. So if you can't get something done in the courts, you can, if you have the support of the media in particular, you can get legislative relief. The second lesson, by the way, is that the states can always give you more relief than the federal government. The U.S. Constitution sets a floor, not a ceiling. So the states under state law can always honor your rights in a manner that the federal government refuses to do that. And there's one other interesting fact about this case, and that is that even though Suzette Kelo's home and her neighbors' homes have all been taken from them, and in the case of Suzette Kelo, it's been relocated, the Pfizer plant never did happen. The hotels never did happen. The commercial office buildings never did happen. And if you go up to New London, Connecticut, where their homes used to be, you will find a vacant lot. And it has been vacant for the entire period of time after their homes were removed. So much for economic development. So to wrap this up, in a free society, we should not have to ask for government's permission to participate in an election, and we shouldn't be forced to buy health insurance or bail out car companies. But the way to minimize those abuses of government power is to have a court system that's vigilant and that ensures that the legislative and executive branches are bound by the chains of the Constitution. And I think, regrettably, the Supreme Court has been occasionally derelict in fulfilling that obligation. And in my view, it is long past time to restore constitutional government. Thanks very much. I hope to answer your questions. So we have a few minutes. So if you do have any questions, yes, sir, in the back.
My question is going back to the Citizens United case. You made it very explicit to say that a corporation doesn't have the right to coordinate with the political party to initiate a media campaign. But to a certain extent, doesn't a corporation then have carte blanche to basically put out as many ads as you want to with shareholder money?
Well, of course, shareholders have an option. You know, you could sell the stock. If you don't like what the corporation's doing with your money, then don't buy the stock. Or if you've already bought the stock, sell the stock. How about corporations' contributions to Planned Parenthood? You want shareholders to have to consent to every action that the corporation takes. The very nature of a corporation is that you have officers and directors that are representing the interests of the shareholders, and if the shareholders don't like the interests that are being represented, the shareholders have this remedy. So yes, it does mean that the corporations could, using shareholder money, they could buy ads, and if the shareholders object, they have a remedy, and if folks thinking about buying stock have an objection, then you'll see the price of the stock going down to reflect that. Yes, sir.
I enjoyed your remarks. I think one of the interesting things about constitutional interpretation is some of the instances where the Constitution is contradictory, or when the Constitution at times can be confusing. And you spoke specifically about TARP recently and some of the problems that you saw in the government's use of emergency funds and related to the Great Recession, as it's been called. And I'm curious to know if you could talk a little about the intersection that you see between the spending power or the Congress clause and the contracts clause, and then some of the emergency powers that have been recognized in the executive branch. I think it's safe to say that the Great Recession was, we were on the brink of potential disaster, and so I'm curious to know your thoughts about how we should navigate the limits for the executive branch when trying to decide how to react to those kinds of circumstances.
Yeah. Well, I think it's probably correct that we were very close to disaster. But bear in mind how we got there. You know, first of all, we had a tax policy that said that dividends get taxed twice and interest is deductible, and so naturally corporations in funding their operations are going to use debt capital instead of equity capital, but there's enormous tax benefits. And then you had the Federal Reserve System with artificially easy money for many decades, and you had this pressure for affordable housing, and most of all you had a regulatory environment that guaranteed banks profits if they made smart decisions and guaranteed them subsidies if they made bad decisions, and most of that was done through Fannie and Freddie, which are quasi-government organizations. So when government itself creates an environment in which this kind of crisis can occur, it's effectively cutting off our arms and legs and throwing us down a hole. Now, it's not fair to then say to the guy who's down the hole, laissez-faire should be able to bring you out of that hole. Of course, government is going to be the only entity that has enough power to get us out of the problem that government put us into. So I don't deny that there was an emergency, and I don't deny that there were things that had to be done that were necessary. So those are mostly policy questions. The constitutional question is more procedural, and that is, if things are going to be done, who should be making the decisions? And my argument was that Congress should have been making those decisions, and there are exceptions for emergencies for sure, but these decisions, of course, lasted for many, many years now, and still are justified under this so-called emergency. And I think that is not adequate justification for what's going on today, and maybe it was adequate justification for what went on in the few weeks surrounding Lehman's collapse, but that's about it. Yes, sir.
Thank you for making the trip from sunny Florida to cold Chicago. I was wondering if you could speak to the way that individual states can restrict our freedoms versus the federal government. Is there a fear from states?
Sure. You remember that back in the beginning, the Bill of Rights only applied to the federal government. The First Amendment says Congress shall make no law. It didn't say anything about the states. So the states could, at the time of the framing, they could pass a law that said that you can't practice Catholicism or you can't criticize a governor. Now, that may have violated the state constitution, in which case it would have been prohibited. But it would not have violated the federal constitution, since the federal constitution, or at least the Bill of Rights, did not apply to the states. We found out over 70 or 80 years that the states can be every bit as tyrannical as the federal government, slavery being the obvious case in point. And so we fought a civil war. We had several constitutional amendments in the aftermath of the Civil War. Most importantly, well, maybe not most important, but at least one important was the 14th Amendment. And the 14th Amendment totally restructured the relationship between the federal government and the states. For the first time, under the 14th Amendment, the federal government could step in if the states were violating these rights that were guaranteed by the Bill of Rights. Of course, this process didn't happen in one fell swoop. This notion of what became known as incorporation, applying the Bill of Rights to the states, took place over a long period of years. It was done provision by provision, free speech, then press, then religion, then protection against unreasonable searches. And it wasn't until last year, as you all well know, in McDonald v. Chicago, that we found out that the Second Amendment was also incorporated. So yes, the balance has been restructured. There now is much more federal power to intervene and stop the states from violating our rights. I'm one who believes that that's a good thing because the states were engaged in activities that did violate our rights. There is always the danger that the federal government will overreach. It has done so. And of course, the proper remedy for that is to make sure you got people on the bench that have a proper understanding of constitutional limits, particularly federalism, separation of powers, limited and enumerated powers, and the sanctity of individual rights. Yes, sir.
Returning back to the vein of exceptions from the Constitution based on emergency, the ubiquitous case on everybody's worst decisions list is always Korematsu.
Is
always Korematsu.
Yeah.
If Korematsu isn't on that worst list because it stands for the premise that there shouldn't be those exceptions, then what value is it?
Korematsu, for those of you who don't recall, Korematsu interned 120,000 Japanese Americans during World War II. The Roosevelt administration claimed that this was justified by emergency. 70,000 of those Japanese were U.S. citizens. 18,000 Japanese Americans were later decorated for valor fighting for the United States in World War II. Ronald Reagan awarded $20,000 in reparations to each of these folks that were still around, including Mr. Korematsu. Ronald Reagan was not known as being soft on treasonous behavior. And then Bill Clinton gave Korematsu the Medal of Freedom, and there was a commission on wartime justice that concluded that there was absolutely no justification for interning these 120,000 Japanese Americans. So there was no emergency that related to the Japanese Americans, and therefore Korematsu, I think, is one of the worst decided decisions ever. I can't say that it's been precedent setting because it's been so bad that nobody ever would cite Korematsu in a Supreme Court opinion. You won't ever see that case cited, even though it's never been overturned. It won't be cited because everybody acknowledges it's so bad. So what it was an era of omission as much as commission, and that is if the courts had stepped in Korematsu and put a stop to this exercise of executive behavior, then it would have set a precedent that I think would have also put a stop to some of the almost as egregious things as George Bush did during the latest Iraq and its aftermath, including things like NSA warrantless wiretaps, creating military tribunals that weren't authorized by Congress, treating everybody as if they were enemy combatants without any determination by either a court or a tribunal as required by the Geneva Conventions, conducting interrogations, but by what at least some people think were using torture, having CIA secret detention camps, incarcerating U.S. citizens like Jose Padilla. I'm not an apologist for Jose Padilla, but U.S. citizens taken off the streets of Chicago and put away effectively incommunicado for years without any right to see a lawyer and any claims being filed against them until the Supreme Court threatened to step in and put a stop to it. All of that, in part, was because the court wasn't very vigilant when it came to Korematsu. Any other questions? Okay, thank you all very much for your attention. I hope that worked out okay. Seeing a nice crowd. 35.